Did you know that over 2.5 million temporary residents in Australia could be at risk of deportation or forced departure under new immigration changes rolling out in 2026? That's not a rumor, it's the reality unfolding as the government tightens the rules, redraws visa pathways, and redefines who gets to stay and who doesn't. Whether you're an international student, a skilled worker, or someone waiting on a permanent residency decision, these laws could directly affect your future. Even people who've lived and worked in Australia for years might be caught off guard, losing their legal status overnight without warning. The scariest part? Many don't even know they're at risk until it's too late. In this video, we're breaking down 10 real immigration laws and changes that could force you or someone you know to pack up and leave. Some of these are already in effect. Are you ready for what's coming?
Number 1. The law that gives government full control. At the heart of Australia's immigration system lies the Migration Act 1958, a law that gives the government sweeping powers over who can enter, stay, or be removed from the country. It's not just some outdated piece of legislation collecting dust. It's the backbone of every visa, every deportation, and every migration decision made in Australia. Under this law, immigration officers and the minister have the authority to cancel visas, detain individuals, or deport non-citizens, sometimes without the need for court intervention. This law is so powerful that even a simple breach of visa conditions, like working too many hours on a student visa or failing to notify a change of address, can lead to visa cancellation. And it doesn't matter how long you've lived here, what job you have, or if you have children enrolled in school. If your visa is canceled under the Migration Act, you could be detained and removed. Worse still, if you're removed once, you may face a ban from returning to Australia for up to 3 years, or more in serious cases. What's truly alarming is how quietly this law operates. Many migrants are unaware of just how much power the government holds over their status. The law doesn't require a criminal conviction for someone to be removed. It simply needs a breach of conditions or a belief that the individual is a risk to public safety or order. If you're living in Australia on any type of visa, this is the one law you should never ignore, because it's the one that can take everything away without warning and without a second chance. Stay informed, stay compliant, and always know your visa rights.
Number 2. Visa cancellations made easier. If you think your visa is safe just because it was granted, think again. Under Section 116 of the Migration Act, the Australian government has the power to cancel visas for a wide range of reasons. But what's even more concerning is that in 2026, these powers have been expanded even further. Now, even minor issues like changes in your employment, questions about your character, or shifts in national security priorities can trigger sudden cancellation. You could be completely unaware that your status is under review until a cancellation notice shows up in your inbox, or worse, at your door. One of the biggest changes affects skilled visa holders, particularly those sponsored under the new Skills in Demand, or SID program. If your employer fails to meet strict sponsorship conditions, like underpaying staff or not reporting changes, your visa could be canceled, even if you've done nothing wrong. In some cases, visa holders are given only a few days to respond before their visa is revoked. If they don't act fast, they could face immediate loss of work rights, detention, or forced departure. The burden is now not just on the government, but on visa holders to constantly prove they are compliant. This legal shift is a game changer, and most migrants don't see it coming. You could be building a life, working hard, and following the rules, and still lose your legal right to stay because of something outside your control. The only way to protect yourself is to stay informed, check your visa conditions regularly, and keep detailed records of your employment and legal status. Because when the rules change, ignorance isn't an excuse, and you don't always get a second chance.
Number 3. Skilled visa rules changed. The introduction of the Skills in Demand SID visa in 2026 has completely changed how skilled workers can live and work in Australia. Replacing the older, temporary skill shortage visa, this new system sounds promising at first, offering clearer pathways and a faster application process. But beneath the surface, it comes with stricter eligibility criteria, tighter compliance requirements, and a higher risk of visa cancellation. If you're currently on a skilled visa or planning to apply, these changes could drastically impact your future in the country. One of the most important things to understand is that under the new SID structure, your occupation must be listed on the updated Core Skills Occupation List, which is reviewed regularly. If your job is removed from the list, even after you've been working for months or years, your visa pathway could be blocked or cut short. In addition, the government now requires both employers and visa holders to meet stronger performance and compliance benchmarks, and even minor slip-ups can lead to consequences. For example, if your employer delays salary payments or fails to submit required documentation, your visa could be at risk through no fault of your own. These changes are designed to prioritize Australian workforce needs, which means migrants must constantly prove they are essential. It's no longer enough to have a valid job offer. You must be in a priority occupation, meet ongoing assessments, and maintain compliance at all times. Many migrants find themselves under pressure to switch careers, apply for reskilling, or even return home if they no longer qualify. The new SID visa may promise opportunity, but it also demands constant awareness and adaptability, because staying in Australia as a skilled worker is no longer guaranteed.
Number 4. Permanent residency is no longer a guarantee. For many migrants, the dream of coming to Australia begins with a temporary visa but leads to the ultimate goal, permanent residency or PR. But in 2026, that dream is becoming harder to reach. The Australian government has chosen to freeze the permanent migration cap at 185,000 places, despite growing demand. This means that while more people are entering the country on temporary or skilled visas, the number of PR spots is not increasing, making the competition tougher than ever. This cap affects almost every migration stream, including skilled independent, state-nominated, employer-sponsored, and family visas. Even if you meet all the eligibility requirements, there is no guarantee you'll receive an invitation, simply because the spots are limited. It's like trying to board an overcrowded flight. You might have a ticket, but you're not getting on if there's no seat left. This has left thousands of long-term residents in limbo, unsure whether their future in Australia is secure or hanging by a thread. If you're on a temporary visa and hoping to transition to PR, it's now more important than ever to plan your pathway strategically. Don't assume your visa will naturally lead to permanent status. Focus on high-demand occupations, improve your English test scores, gain work experience in regional areas, and stay alert to changes in eligibility rules. One small shift in policy can knock you off the list entirely. In this new system, being qualified isn't enough. You have to be competitive, proactive, and prepared. Because once those 185,000 places are filled, you may have to wait another year or risk losing your chance altogether. Number 5. Temporary visas under watch. Temporary visas have long been seen as the first step toward building a future in Australia, whether for study, work, or bridging the gap between two permanent options. But in 2026, the landscape for temporary visa holders is shifting rapidly and not in their favor. The government is now placing stricter controls and digital surveillance on temporary visa pathways, with a clear message: only those who follow the rules perfectly will be allowed to stay. That means even minor errors, like uploading the wrong document or missing a notification, can lead to delays, refusals, or worse, forced departure. One of the biggest changes is the introduction of real-time compliance monitoring systems, where the Department of Home Affairs tracks visa holders' activities more closely than ever before. For example, international students who switch courses without approval, or workers who take extra shifts outside their visa limits are now flagged automatically. These systems can issue instant alerts and initiate reviews, and many people don't find out until it's too late. Even bridging visa holders are under pressure, with new conditions applied based on visa history and future risk. What makes this more stressful is how quickly the rules are changing, leaving many applicants confused and unprepared. A visa condition that was valid 6 months ago might be grounds for cancellation today. If you're on a temporary visa in 2026, the only way to stay safe is to treat every update, email, and requirements seriously. Double-check your visa subclass conditions, keep your contact details updated, and seek legal help if anything seems unclear. Because in today's system, a temporary visa isn't just a waiting period, it's a tightrope, and one wrong step could send everything crashing down. If this video is opening your eyes to things you didn't know, tell us in the comments which law shocked you the most. We put a lot of effort into researching and simplifying these complex topics, so hit that subscribe button. It's just one click, but it keeps this channel alive and growing.
Number 6. Detention is still a real possibility. Many people believe that immigration detention in Australia is a thing of the past, or that it only applies to illegal arrivals or criminals. But under current laws, especially in 2026, detention remains a very real and legal consequence for anyone found to be unlawfully in the country. If your visa expires, is canceled, or you breach conditions and fail to act quickly, you can be detained by immigration officers without needing to go through the courts first. It doesn't matter if you've been living in Australia for years, have a job, or even a family. The law still applies. What's more alarming is that detention can happen without warning. You might think you're safe while waiting for a new visa application to be processed, but if your bridging visa lapses or is refused, you could be picked up by authorities. People have been detained at airports, during workplace inspections, and even at home. Some are held for days, others for weeks or longer, while arrangements for their removal are made. And if you're detained, your chances of applying for a new visa from within the country drop significantly, leaving you with limited options and very little time. The only way to avoid this outcome is through constant vigilance and preparation. Always know your visa expiry date, check your application status regularly, and respond immediately to any communication from the Department of Home Affairs. If you're unsure, seek legal or migration advice rather than assuming everything is fine. In 2026, the system is strict, fast-moving, and unforgiving. And once you're caught in the detention process, it's extremely difficult to reverse. Don't wait for a knock at the door. Stay ahead of the rules before they catch up to you.
Number 7. Bridging visas are riskier. For many migrants, a bridging visa is seen as a safety net, a way to legally stay in Australia while waiting for another visa decision. But in 2026, that safety net has become much thinner. New changes have introduced stricter conditions, limited work rights, and shorter validity periods, making life on a bridging visa more uncertain than ever. If you're relying on one, you must understand that it's no longer just a temporary solution. It's now a legal tightrope, and slipping could mean detention or removal. One major change is that not all bridging visas come with automatic work rights anymore. In some cases, applicants must submit a separate request and prove financial hardship or exceptional need to be allowed to work. This puts added pressure on people already struggling to support themselves while waiting on decisions that can take months or even years. And with more applications being refused or delayed due to incomplete documents or small errors, the risk of suddenly losing legal status is rising fast. The Department of Home Affairs is also using updated digital monitoring tools to track visa compliance in real time. If you leave Australia without permission, work outside approved hours, or breach any condition, even unknowingly, your visa could be cancelled.
That's why it's more important than ever to read and understand every line of your grant notice. Check your Vivo details regularly and keep all correspondence from immigration safely stored. A bridging visa used to mean time and flexibility. In 2026, it means walking a very narrow legal line, where a single mistake can cost you your future in Australia. Don't treat it lightly. It's not just paperwork, it's your legal lifeline.
Number 8. Students face tougher rules than ever. In 2026, international students, once seen as the future of Australia's skilled workforce, are now facing some of the toughest immigration rules in decades. What was once a relatively smooth path from education to employment is now full of strict conditions, tighter monitoring, and limited options for staying after graduation. The government has made it clear, studying in Australia no longer guarantees a chance to stay. For thousands of students, this shift is creating uncertainty, stress, and a rush to meet new, harder-to-reach expectations. One of the biggest changes is that students are now being assessed not just on academic performance, but on genuine intent to study, financial stability, and long-term compliance. Those who switch courses without approval, fail subjects, or breach work-hour limits risk visa cancellation. Even minor mistakes like forgetting to update your address can be flagged. On top of that, the number of post-study work visas has been reduced in several fields, especially those not listed as high priority for the Australian economy. This means your degree might not help you stay unless it's directly tied to a critical occupation. The government has also introduced new systems to track student visa holders in real time, including academic progress and employment data. Institutions are required to report more frequently, and students are expected to be more transparent than ever. If you're an international student in 2026, it's no longer enough to simply pass your classes. You must understand your visa conditions fully, stick to your study plan, and seek migration advice before making any changes. Because in today's immigration system, one wrong decision, even an innocent one, can close the door to your future in Australia permanently. It's a harsh reality, but it's one you need to be prepared for.
Number 9. Point system is tougher and more selective. If you're planning to apply for permanent residency through a skilled visa, the points-based system is your gateway, but in 2026, it has become more competitive and more selective than ever before. The government has shifted its focus toward targeting only the most in-demand occupations with high English proficiency, strong work experience, and proven economic contribution. This means the minimum points required for an invitation have increased dramatically, leaving many qualified applicants waiting endlessly without a response. The new system doesn't just reward qualifications, it now puts heavy weight on where you've worked, your salary level, and even your location within Australia. Migrants working in regional areas or earning above a certain income threshold are now given priority, while others with lower scores are pushed to the bottom of the list regardless of their time in the country. The independent skilled stream, once a reliable path for high-scoring applicants, is now extremely limited, with most invitations going to those sponsored by states or employers. This shift has left many long-time temporary residents feeling trapped, stuck on bridging visas, unable to move forward. If you're aiming to secure PR through points, you must take a proactive and strategic approach. Boost your English scores, pursue additional qualifications, and consider relocating to a state with better nomination chances. Don't assume your current points are enough, because what was competitive last year may be completely unviable this year. In 2026, it's not just about meeting the minimum, it's about outshining thousands of other applicants fighting for the same spot. The point system has become a game of precision and performance. One weak area can drag you down, while one smart move can fast-track your journey to permanent residency.
Number 10. Employer mistakes can cost you. In 2026, the pressure isn't just on migrants, it's also on the employers who sponsor them.
But here's the catch. If your employer breaks the rules, you could still be the one who suffers the consequences. Under the updated immigration laws, employer compliance is now closely tied to the legal standing of the visa holder. That means if your sponsor fails to meet key obligations like paying the correct salary, providing safe working conditions, or reporting changes to your role, your visa could be canceled, even if you had no part in the violation. These rules are part of the government's crackdown on exploitation and fraudulent sponsorships, but they've created a serious risk for genuine skilled workers. Many migrants assume that once they have a job in sponsorship, they're safe. But in reality, the Department of Home Affairs monitors both the employer and the employee. And if the business is found non-compliant, the sponsored worker is often the first to be affected. In some cases, workers have been left without status or income overnight, forced to leave the country or scramble for a new sponsor within tight deadlines. To protect yourself, you need to be proactive. Keep copies of your contract, pay slips, tax records, and correspondence with your employer. If something seems off, like being underpaid or asked to do duties not listed in your contract, don't ignore it. These could be signs of non-compliance that could put your visa at risk. It's also wise to check if your employer is on the approved sponsor list and has a clean record. In 2026, sponsorship is no longer just a formality, it's a shared responsibility. And if your employer fails, the system won't protect you unless you're prepared.
As we've seen, Australia's immigration system in 2026 is no longer the predictable, step-by-step journey it once was. It's become a highly selective, closely monitored, and rapidly changing landscape, where one wrong move, even a small one, can lead to cancellation, detention, or forced departure. Whether you're here on a student visa, a skilled worker visa, or waiting on permanent residency, you must stay ahead of the rules. Understand every condition tied to your visa, and never assume you're safe just because you're currently legal. The truth is, most people don't realize how vulnerable they are until it's too late. Laws are becoming tighter, technology is tracking compliance more closely than ever, and the margin for error is shrinking. This isn't meant to scare you, it's meant to prepare you. Because if you're informed, you're empowered. And in a system that's this strict, knowledge is your best protection. Now is the time to take control of your own future in Australia. Don't wait for the department to notify you. Be proactive, check your visa conditions, follow the updates, and seek expert advice if you're unsure, because the difference between staying and being forced to leave might come down to what you didn't know or what you didn't do in time. We hope this video gave you clarity and possibly even helped you avoid a mistake that could cost everything you've worked for. If you've made it this far, we'd love to hear from you. What part of Australia's new laws surprised you the most? Drop your thoughts in the comments below. We read every one of them. And if you found value in this video, please support our channel. We put hours into researching and breaking down these updates, so hit that subscribe button. It's just one click, but it means everything to us.